Hello aspirants. So prelims examination is over and hopefully all of you have done well. According to me, the paper was moderate, not very difficult, not very easy, but I don't think it will make much difference because it is, if anybody has prepared it properly. When I say properly, I don't mean that they have just studied and studied without mindlessly. So if they have studied things logically and they have developed certain skills along with the information, they would have done well. So we are presenting you the model key or the key of the answers, and hopefully this will help you to find out like your score, and you will get greater clarity about your mains preparation. So anyway, I will always suggest that whether you are clearing or you are not clearing, all of you please start preparation of mains, because this time you can say the time is less between the prelims and mains, and we cannot keep on waiting. And whether this time or next time, you have to remain in the process of the examination, because the moment you get complacent, you again go back to ground zero. So don't get complacent, and unless you will not prepare in the mood that you are going for mains, and you will think that I will prepare for next time, you will never be able to give that much time and that much attention which you will otherwise give. There is a law in public administration which says that more is the time, more work expands, and more time we do unnecessary things. So after today or tomorrow, don't consult the answer keys again and again, and don't think, because whatever you have done in prelims, that is done. Think about the next stage of examination. Fine. So these are certain qualities that make a difference between the successful and unsuccessful candidate. I always emphasize on personality. I always emphasize on your attitude. So your attitude towards the examination matters the most. So let me discuss polity, and this time more number of questions than the last year. Around 18 questions can be considered as polity questions, and the last year polity was comparatively easy. This year, fine, but some of my favorite areas, as always, constitutionalism and separation of powers, etc. Judiciary, I always emphasize in my classes that appointment of retired judges, ad hoc judges. So since last so many years, this is the predictable area. So I'll say that paper has been on the predictable, more or less. You cannot completely consider it, but yes, it has been on the predictable ground. Polity questions may appear factual, but to be able to solve, you definitely need conceptual clarity. Fine. So now let me start with the paper. So the first question, now I have picked from C series, but it will not make any difference because I have collected all the questions at one place. Fine. So the first question is, under the Indian Constitution, concentration of wealth violates. See, because there is a direct provision in the Constitution, you can go for the option B, the directive principles of state policy. Had this not been directly written, then you could have thought about the welfare state, etc. But it is already mentioned, the concentration of wealth. And whenever I teach in class, I always emphasize that in the topic of directive principles, always have a look over the amendments. Fine. So this concentration of wealth issue, this has been discussed in 25th Amendment Act, and 25th Amendment Act is related to land reforms. Fine, and there is a long list of cases related to it, and land reforms is to go for the deconcentration of wealth. Fine. So 25th Amendment Act added Article 31C, and Article 31 mentions about Article 39B and C. Fine. So Article 39C says that a state will take effort to minimize the concentration of wealth, and that becomes the basis for land reforms. Okay. So whenever you study polity, there are certain topics, amendments are always probable questions. Fine. So 39B and C. Ownership and control of the material resources of the community are to distributed to serve the common good. And C is specifically saying operation of economic system should not result into the concentration of wealth. Now the next question is, what is the position of right to property in India? In almost like in all QEPs and other cases or in other classes, I have already clarified the doubt related to right to property, and then I have always been telling you how to make a difference between constitutional right and the legal right. Fine. So right to property as per under Article 300A, when it was eliminated, fine, it was repealed by 44th Amendment Act, and in 44th Amendment Act it was a fundamental right. So now it has become a legal right and it is available to all persons. Fine. It is very important that you should know why it is available to all persons. Fine. Because there can be a confusion whether it is available only to citizens or it is to all persons. It's not necessary that you have to mug up the constitution. You have to understand that when we invite the foreign investment, foreign investors will naturally look for some type of protection for their property rights. So, you know, China is politically a communist country, but still China has that legal right to property, because you always expect that the foreign investors will expect the protection of their investment. So it cannot be only for the citizens, it has to be for all persons. Fine. And here let us see legal right available to citizens only, because it is mentioning citizens only, we are cutting it. Legal right available to any person. Fine. Any person aspect is fine, but we have to see all options. Fundamental right available to citizens only, so this is anyway repealed. It is neither fundamental right nor legal right. This is also wrong. Fine. Because it is a legal right. For two basis, for two logics you can give it is a legal right, because it is mentioned in the Constitution, and Constitution is itself a fundamental law. So when it is mentioned in the Constitution, Constitution is a law, so it is bound to be a legal right. Fine. But if we look into the language of the Constitution, fine, so the answer is B here. If we look into the Constitution, persons not to be deprived of property save by authority of law, means it is saying that authority of law, it means that executive alone cannot take away right to property or limit, etc. it requires legislative action. Fine. So this is done by formulation of laws. Fine. So what you can say, that right to property is the constitutional right also, because it is mentioned in the constitution. ठीक है, अगर कॉन्स्टिट्यूशन में ऐसा हो कि persons not to be deprived of, fine, by this save by authority of law, अगर ये mention ही नहीं होता तो it would have been purely legal right, but still it is a constitutional right also as well as a legal right. मैंने QEP और सभी क्लासेस में बताया था how to make a distinction. तो fundamental right means for which article 32 is available. Constitutional right is if you have to change that particular right, you have to go for amendment. Legal right is which can be amended by simple law, by simple majority, by ordinary law, we will say. So the land acquisition acts, etc., they are passed by parliamentary laws, okay, by simple majority, or you can say they are ordinary laws. Fine. So it is a constitutional right plus it is a legal right. On what basis I am saying? Because it is protected by the authority of law. Now if you see the option, the more correct option would have been it is a constitutional right as well as legal right, but they have not mentioned constitutional right at all, but it is a legal right, so obviously it is going to be B. So polity, if you will understand why our constitution is so logical, अगर आप लॉजिक से पढ़ोगे आपको रटना ही नहीं पड़ेगा, आप हमेशा इंटेलिजेंट गेस कर सकते हो. ठीक है. नाउ व्हाट वाज द एग्जैक्ट कॉन्स्टिट्यूशनल स्टेटस ऑफ इंडिया on 26 January 1950? So you know, by 42nd Amendment Act the word secular and socialist were added. So India was what? India was a sovereign democratic republic. Fine. So simple question. Hope you remember the class notes. We have sent you both the two preambles, before 26 January and after that, because I knew there is a possibility of such questions, because lot of articles were coming. Fine. Because by mistake also government had published one day the original form of the this preamble. Okay. Now constitutional government, one of my favorite questions. I always start in all the batches in QP and all, I always emphasize on that constitutionalism is rule of law. So constitutional government means limited government. If government is not limited, why do you require constitution? A dictator is not going to have a look on a constitution. Fine. So whether you have a constitution or you don't have a constitution, it doesn't matter in the dictatorship. Fine. It only matters in democracy. What is democracy? Democracy is a rule of law. So constitutional government means a representative government of a nation with a federal structure? No. A government whose head enjoys nominal power? No. These type of questions you can do wrong if you are not conceptually clear. They appear to be simple but actually not. A government whose head enjoys real power? Not at all, because then to it is something different. Now or dictatorial, a government limited by the terms of the constitution. Fine. So constitutional government, answer is D. Now consider the following statement in respect of Bharat Ratna and the Padma Award. Now the question is not asking which is correct, question is asking which is not correct. Fine. So Bharat Ratna and Padma Awards are titles under Article 18 Clause 1. The answer is no, they are not titles. You know that Supreme Court in Balaji Raghavan case held that these awards can be given and they are not going to be considered as the titles. Fine. So this is wrong. Padma awards, which were instituted in the year 1954, were suspended only once? No, they were suspended 2 times. The number of Bharat Ratna award is restricted to a maximum of 5. No, they are restricted to the maximum of 3. So all the 3, which of the following statements are not correct? Fine. So all the 3 are not correct. So answer will be D. Fine. So D is the answer. For your reference, this is from the site of Bharat Ratna. So you can rely on this. So Bharat Ratna award is restricted to maximum of 3. Fine. And they were instituted in the year 1954. Padma award, that is announced every year except for brief interruptions during 1978, 79 and 93 and 97. Fine. So Padma awards were suspended only once? No, Padma awards were suspended 2 times. Fine. This is from their website itself. Now, with reference to India, consider the following statements. Judicial custody means an accused in the custody of the concerned magistrate. Correct. And such accused is locked up in police station and not in jail. So this is so wrong. Fine. So this becomes police custody if you are in lockup. But if you are in jail, fine, so that becomes a judicial custody. Fine. So what is wrong here? They should not have written police station. A judicial custody means an accused is in the custody of the concerned magistrate and such accused is locked up in police station, not in jail. So this part becomes wrong. So 1 is wrong. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. So this is right, because that is the very purpose of putting a person under the judicial custody. Fine. So they are asking which one is correct. So you can say B is our answer. Only 2 is correct. Fine. So here only 2 is correct. So for your reference, I have given these notes. You can have a look into it. So police custody means police has a physical custody, while judicial custody means accused is in the custody of the concerned magistrate. Informer accused is lodged in police station lockup, while in the judicial custody in the jail. When police takes a person into custody, the CRPC kicks in and they were produced by him before a magistrate. Police custody with permission to interrogate. So during judicial custody, police officer is not allowed to interrogate without the permission of the magistrate. Fine. So court may allow the interrogation. This means magistrate may allow. Now with reference to India, consider the following statement. When a prisoner makes out a sufficient case, parole cannot be denied to such person because it becomes a matter of his or her right. So parole is not a matter of right, because there are 2 terms, parole and furlough. Fine. So furlough is where you can be given opportunity to stay with your family for a limited time. So that becomes the right. But parole is not a right, because in case of parole, instead of serving the term in the prison, you are permitted, you can stay with your family. But parole is based on the basis of your good character. Fine. So you also need to understand that person can be released on bail, but when you are released on bail, then you have to pay money. Fine. So that is something you purchase your release, but parole is something that you earn. Why you earn? Because of your character, but it is a discretionary power, fine, of the authorities. It's not that parole becomes a right. Fine. So prisoner makes out a sufficient case, parole cannot be denied to such person because it becomes a matter of right. It is not a matter of right, fine, because you can stay out. Furlough is a matter of right because you are going for some time. State governments have their own prisoners rule, yes, because it comes under the concurrent list. So this is correct. It means which of the following statements are correct. Fine. So 2 only. 1 is not correct. Fine. If for further confirmation, you can look into the case of Kantilal Nandlal Jaiswal case. Supreme Court in the case this Nilofar Nisha clearly stated that grant of parole is not a right vested with the prisoner. It is a privilege available to the prisoner on fulfilling certain conditions. Fine. So it is not a right. Now, at the national level, which ministry is a nodal agency to ensure the effective implementation of Scheduled Tribes and Other Forest Rights Dwellers Act? This is a very favorite area. You can always expect even a question in mains. Fine. So in the act itself makes Ministry of Tribal Affairs is the nodal agency. Fine. So the answer here is D. Fine. I have given this. The Ministry of the Central Government dealing with the tribal affairs or any other officer authorized with the central government shall be the nodal agency. Fine. So now a legislation which confers on, now this is a good and conceptual question and the people with conceptual clarity can solve it. Fine. Because the confusion may land up into wrong choices here. A legislation which confers on the executive or administrative authority as unguided and uncontrolled discretionary power in the matter of application of law. Uncontrolled and discretionary powers in the matter of law violates which article? Fine. So uncontrolled and discretionary power, it violates what? It violates rule of law. Fine. And which article of the Indian Constitution deals with rule of law? Obviously Article 14. So if you are not clear, you may get confused with this article, but the answer is Article 14 because you are talking in terms of rule of law. Now, which one of the following in the Indian polity is an essential feature that indicates that it is a federal in character? Fine. So the independence of judiciary is one of the features, but there are other features. So don't go fast and you have to see all the options. The union legislature has elected representative, nothing to do with this. Union cabinet can have elected representative, again it has nothing to do. Fundamental rights, nothing to do. Fine. So obviously independence of judiciary. Answer is A. Because why independence of judiciary? Because there will be division of powers. For example, 7th schedule. Now if a state makes a law on the central government subject or central government makes a law on state subject, there will be a dispute. To solve that, to maintain that federal character, you will have to go to the judiciary, and judiciary applies what? Judiciary applies doctrine of colorable legislation, doctrine of pith and substance. So what is federal form of government? Federalism comes from the word fetus. Fetus means government by contract. So there is a contract between the two parties. Fine. So there can be a contract among states or state and federal government. And Whenever there is a contract, you need a arbitrator. So what is the role of judiciary? Arbitration. Fine. Resolution. For that, judiciary has to be independent. Now, which of the following term best defines? So maybe in the notes you can see that I have always talked about Montevideo Convention. Fine. So if you will see the notes, you will find this, that what is a state? A community of persons permanently occupying a definite territory, independent of external control and possessing a organized government. So in Montevideo Convention, population, government or territory and sovereignty. Fine. So the answer is A. But let us see here why it is useless. Natural rights is not a concept. A person living in a territory for long time, culture, tradition, vague hai. Society permanently living, executive responsible, this is all vague. Now, with reference to Indian judiciary, this question though I always expect, we always do in QEP. Fine. With reference to Indian judiciary, any retired judge of Supreme Court can be called back to sit and act. There is a provision for retired judges. There is a provision for ad hoc judges. Fine. Under Article 128, and there can be a doubt, can be appointed by CJI with prior permission of President of India. So yes, this is correct, because ultimately when you appoint the regular judges, it is formally done by President of India. So in this case, it is with the prior permission of President of India. A High Court in India has a power to review. Yes, High Court also has a power to review. Now what is the logic? Because under the Constitution, under Article 226, even High Court is a court of record, and any court of record will always have this power. So both the two answers are correct. So C is a option. Fine. So what is an option here? C is a option. Now next is, if you want a reference, you can say, being a court of record, this is a Kerala High Court's recent judgment, that High Court can review its own judgment under Article 226, Potta Kalati Ramakrishnan versus Tirur case. Now, with reference to India, consider the following statement. Fine. So, there is only one citizenship and one domicile in India. Correct. A citizen by birth only can make head of the state? No. When I was doing comparative politics, I compared that in USA, a natural born citizen can be president, but in India, we don't make a distinction. Fine. So in India, head of the state is not necessarily has to be citizen by birth. A foreigner once granted the citizenship cannot be deprived. No, they can be deprived if they misbehave, if there are clauses that are written. So foreigners getting citizenship will come under which provision? Citizenship by naturalization. So cannot be deprived? No. Fine. So the answer is one only. So the answer becomes A. Fine. And if you want to refer this, और ये तो एलिमिनेशन से ही हो सकता था. फाइन. सो 2 तो होना ही नहीं है, 3 भी नहीं होना है. फाइन. एनीवे दिस इज ऑल्सो वेरी ऑब्वियस. नाउ विच ऑफ द फॉलोइंग factors constitute the best safeguard of liberty in a liberal democracy? Fine. So liberal democracy, committed judiciary. You can do the mistake, find that judiciary, but you will not see committed judiciary. Committed judiciary is against the liberal democracy. When Indira Gandhi called for committed judiciary, she was charged that she is undermining the idea of democracy, because judiciary is supposed to be independent, not limited. Centralization of power can't be safeguarded. Elected government but that depends on the other choices. Separation of powers is D is the best option, because who has given separation of power? Montesquieu. What is the title of his book? The Constitution of Liberty, and another book is Spirit of Laws. Fine. So in liberal theories, starting with the father of liberalism, John Locke, we talk about separation of powers, because Locke said that you cannot protect the liberty without separation of powers. So whether by Locke, whether by Montesquieu, D will be the answer. Now, we adopted parliamentary democracy based on British model. Here the language is little bit confusing. Fine. But let me see. So we adopted the parliamentary democracy based on British model, but our model differ from that model. This question also I have always been telling: parliamentary sovereignty, constitutional sovereignty. See, I in the comparative constitution as well as in the topic of doctrine of basic structure, I have emphasized this time and again. Fine. So as regards legislation, British Parliament is supreme or sovereign, but in India the power of Parliament to legislate is limited. Correct? Fine. So this was pronounced in doctrine of basic structure when Parliament was bent on emasculating the constitution of its vital features. In India, matters related to the constitutionality of an amendment of an act of the Parliament are referred to the Constitution bench by the Supreme Court. Now the problem is here the language is little bit unambiguous. Language, what they meant by. So whenever I have been discussing the doctrine of basic structure, I told that Supreme Court is the only court, Supreme Court of India is the only court in the world that has power to review the amendments when American court does not have this power. This makes Supreme Court the strongest court in the world. Fine. So as a matter of fact, in India, matters related to the constitutionality of law are referred. They are referred. In other countries, they are not referred. Fine. So ideally, they should have written that can be referred, because are referred seems to be necessarily referred. But if you see the history, like whenever UPSC has to ask are referred, they mean necessarily referred. ठीक है, तो इसलिए आर रिफर्ड को हम लोग सही मान सकते हैं. इसका मतलब है जब ये आर रिफर्ड लिख रहे हैं तो दे आर मीनिंग टू से आर रिफर्ड लाइक, और इट मीन्स दे कैन बी रिफर्ड. फाइन. अगर इनको ऐसा होता कि नेसेसरली वाला जो इश्यू होता तो ये लिखते. ठीक है, तो ये आर रिफर्ड तभी लिखते हैं जब ये कैन वाला कंसेप्ट होता है, अगर हम प्रीवियस उसके हिसाब से चलते हैं. और अगर इन्हें मस्ट वाला होना होता है तो ये नेसेसरली लिख देते हैं. तो इसलिए ये दोनों ऑप्शन सही हैं. सो दिस इज इंडिया इज द ओनली कंट्री वेयर दे कैन बी रिफर्ड. आइडियली इनको कैन बी लिखना चाहिए, बट कैन बी की जगह ये आर लिख रहे हैं. ठीक है, तो इसलिए ये स्टेटमेंट हम सही मानेंगे. अगर ये क्वेश्चन होता कि नेसेसरली रिफर्ड तो ये ऑप्शन गलत होता. ठीक है, तो हियर व्हाट विल यू सी दैट बोथ आर करेक्ट. फाइन, बोथ द टू ऑप्शंस आर करेक्ट. नाउ with reference to the union government, consider the following statement. Gopal Swami Iyengar committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reforms. This is the reason I always tell you, prepare for mains first and governance also, and in the coming years I can predict that the number of questions from governance are going to increase. Anyway, it's a factual question, and this is wrong because this was not suggested by Gopala Swami committee. This was suggested by first ARC. Now, in 1970, Department of Personnel was constituted on the recommendation of ARC, and this was placed under Prime Minister's charge. No, it was placed under Cabinet Secretary. Fine. So both are wrong. The answer is D. Right to privacy, Puttaswamy case, Article 21 related to right to live with dignity. Fine. So Puttaswamy case, because it is a part of right to life, which means right to live with dignity. Dignity movement ही है पूरा. Now, in India, there is no law restricting the candidate from contesting in one Lok Sabha election from 3 constituencies. तो law तो है not more than 2, और ये भी सजेस्ट किया जाता है ये भी खत्म कर देना चाहिए because it results into unnecessary by elections. Fine. So this is from Representation of People Act 1951, section 33. So in 1991 Lok Sabha election, Shri Devilal contested from 3 Lok Sabha constituencies. That is right, but you can say that when they cannot stand from more than 2 constituencies, the reason is this was made in 1996. This provision was added in 1996. So he has done this. ये तो हो गया wrong. As per existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies. The answer is no. This is one of the reforms suggested, that in India, why should we be paying, why should taxpayers be paying? इससे related अभी जैसे वेस्ट बंगाल में सीट छोड़ी गई और ममता बनर्जी के लिए सीट बनाई, सो एक petition भी pending है जिसका judgment 9 नवंबर को आएगा. ठीक है. और अगर हम लॉजिकली भी देखें तो ये सजेस्ट किया जाता है दिस इज वन ऑफ द इलेक्टोरल रिफॉर्म्स. फाइन. वो आपका 33 क्लॉज ये सेक्शन 33 सब क्लॉज 7 एडेड इन 1996. So that's all for polity. Our teachers will be discussing other sections also, and wishing you all the best. आप ज़्यादा 2 दिन इसमें बर्बाद नहीं कीजिए और एक हफ्ता अपने को रिलैक्स करिए, रिजुविनेट कीजिए और फिर से मेंस के लिए लग जाइए. बिकॉज डोंट स्लीप, अराइज अवेक एंड डोंट स्लीप टिल योर गोल इज़ नॉट अचीव. और कोई भी लक्ष्य मनुष्य के साहस से बड़ा नहीं है इस ईयर या नेक्स्ट ईयर, लेकिन हमेशा आपको यही मान करके प्रिपरेशन करना है कि मैं अभी एग्ज़ाम देने जा रहा हूँ, वरना आपका प्रिपरेशन कभी भी उस फॉर्म में नहीं हो सकता जो यूपीएससी के लिए आवश्यक है. धन्यवाद.